Antonio Lamar Harris.
Thank you, sir. All right, this will be case 23-056524, State of Michigan versus Antonio Lamar Harris. Counsel.
Thank you, Judge Steve Vincent, for the people.
Right for Rob P. 3665 on behalf of Mr. Antonio Harris. Waive readings and view. Harris for the advisory.
Thank you. Court will enter not guilty plea on your client's behalf as to bond.
Thank you, Judge. In this case, Your Honor, it appears the defendant was just recently arraigned and given a generous personal bond on a no contact order, disobeyed that order. He returned back to the residence that was previously stated there were to be no contact. He was armed with a firearm. He approached the complainant and told the complainant to try to get in the house now, bitch. For the record, apparently the complainant resides or previously resided at that home, but that was the address where defendant specifically had a no contact. As a result, Your Honor, in lieu of all of the facts, that this was just the defendant was just previously arraigned and given the opportunity and didn't take that opportunity, people would be asking for a $25,000 cash no insurance cost.
Thank you. Defense counsel.
Now, for the prosecutor, he has a pending case. He was just arraigned Spain. Now, I talked to Mr. Harris this morning, Judge, and I'm going to be straightforward. He told me that one of the things that he thought he could do was to have a one-time visit to get his belongings. That was it. He tells me that he goes to the location, Judge, does not get out of the vehicle. His brother drives him to the location. He never gets out of the car. Brother goes in the house, feeds his cats. He has cats, I guess, that the complaining witness the cat put in the home. But he said he never got out of the car, he got his work clothes, and he left. Now, I would note, Judge, that Mr. Harris, initially, Judge, that when the police were called out to the scene on April 18th, Mr. Harris was not arrested at that particular time, Judge. They took a report, and at that point, they went back and filed charges and filed a warrant based on the information that they got. But and just talking to Mr. Harris, Judge, one of the things my first thought was, why would you go back to a place where you weren't supposed to go back and just had a case with one person days ago? And he's explaining to me what the thought process was. One time he did work clothes, and showing the delivery track, I'm a work clothes. And I'm going to be straightforward. So that's why he never went back, never saw it, live before him, obviously, still applications, and got the story out. But he never committed the exact same crime that he was out on bond for the exact same thing. So that's why I wanted to report.
Thank you, counsel. So, April 18th, afternoon docket, he gets arraigned by my colleague, given a personal bond. My colleague tends to be very clear in what his bond conditions are. Rarely is he one to leave a defendant guessing at what he or she can or cannot do. Bond conditions, as I understand them, were first, no contact, no weapons, no drugs, no alcohol, and no contact with the Norfolk Street address. That's the afternoon docket, 2:30 or sometime thereafter. 6:50, 4 hours later, about enough time to get processed out of DDC. He is back in contact with the complainant, possessing a firearm at the Norfolk Street address. Allegedly.
That's a big word, Judge. You gotta use that word. You can't just say he was back. Allegedly is a big word. Now, the honorable magistrate, chief magistrate gave him a personal bond, Judge. It's pretty much the same fact. Now, my client calls himself doing what he thought was right, not really having contact with that person. And when you say go back to the address, Judge, he went back with his brother. He stayed in the car, according to my client. Now, you know, obviously I wasn't there, so I don't know exactly what happened, but this case is gonna have to be taken throughout this process. And I'm thinking, Judge, that my client wasn't arrested that day when the police got called. I don't know if the police went in the house, looked for him. He wasn't there, Judge, because he wasn't trying to have contact with this person. He knew better. That's why he asked his brother. He said, brothers, can you take me to get my work clothes? I can't have contact with the complaining witness. I can't do that because I'm an order. So, you know, maybe it was a little unorthodox. He shouldn't have even gone on the block, Judge. I mean, I get it.
Unorthodox?
Yeah, well,
I'd say, counsel, what to paraphrase a famous line, what we got here is failure to communicate. So we're going to communicate a little better this time, right, Mr. Harris? There will be no firearms in your possession. Is that clear, sir?
Have none. Yes, sir.
You're not to go to have any contact with the complaining witness, and you are not to go back to Norfolk, not once, not with a police escort, not ever. Is that clear?
God, Your Honor, I didn't. You know what I'm saying? But Your Honor, he did. My brother.
I don't say that, but look, he put his hands up. He understands that he's not going on the block. He's not going anywhere near that.
Court was set bond, 100,000 cash or surety. Bond rehearing date, Monday morning, 4/24. Probable cause conference, 4/28. Preliminary exam, 5, is this a 4? May the 4th. Both of those last hearings are in front of Judge King here in 36th District Court. Thank you, sir. You can step aside.